Okay, so let's suppose you've been fired. You think it might be for a violation of the Human Rights Code, such as age, gender, disability, religion, whatever it may be. And you're trying to determine if you want to file a human rights complaint or sue for wrongful dismissal, or maybe do both. So there's significant differences between a human rights claim and a wrongful dismissal claim that you have to be aware of. And if you choose the wrong avenue, you could be making a big mistake. So let's just go over the differences. First of all, in terms of a human rights complaint, there has to be an essential foundation that there's a breach, obviously, of the Human Rights Code. Wrongful dismissal doesn't matter, just need a termination, no cause. The second issue is the process. In the human rights process, apart from Ontario, which I'll asterisk presently and come back to it, in the human rights process, there's no examination for discovery. You go to hearing, you don't have any idea what the evidence is going to be. You may anticipate it, but there's no evidence under oath you can use for purposes of cross-examination. Unlike wrongful dismissal in a civil proceeding, apart from small claims court, there's examination for discovery. You know really what the opponent's going to say, and there's a much more detailed production of evidence before the case goes to court. Now, in Ontario, again, you can sue civilly for a human rights complaint and wrongful dismissal at the same time. So in Ontario, if you sue civilly, you do get discovery evidence ahead of time. The third big difference is the issue of liability. That is, in the human rights case, it's a much easier path if you think you have a human rights claim to show liability against the company. I'll discuss that in detail later. In a wrongful dismissal claim, the opposite is true, where if the company is asserting cause for termination, then they have to prove the cause for termination. There's also a big difference, most importantly, in the damage claims you can make in a human rights case against a wrongful dismissal case. So let's break that down. In a human rights case, there's basically three components of damages if you show a liability. First of all, emotional suffering. It's called different by different vocabulary, but that's basically the essence of it. Secondly, there's a claim for lost income that goes up until the date of hearing, or may go up until the date of hearing. It's not quite as simple as what I'm saying. And there's a claim for reinstatement, and there's also a possible claim for future economic loss. In a human rights case, there's no punitive damages and no costs being awarded. Now, if you contrast that with a wrongful dismissal case, absent unusual activity at the time of termination, there's no claim for emotional damages. There is a claim for lost income that's capped by the notice period. Human rights has no cap, such as a notice period. The lost income claim goes to the date of hearing. So big difference between wrongful dismissal and human rights. Wrongful dismissal claim, there may be a contract that caps the claim. We'll discuss that in more detail later. The contract in human rights, if it caps the severance entitlement, has no bearing. So there's big differences, and also, again, in wrongful dismissal, there's no future loss claim beyond the date of the notice period. So there's a lot of differences between the two, and I've just summarized these. We'll go into more detail later, but to understand the way in which you want to proceed, you have to understand the basic components of each claim. It's not simple, and it's very, very important to appreciate these differences before you make the decision on how you want to proceed. Also, in human rights cases, each statute may cap the amount of compensatory damages for emotional suffering. The only ones that do that are Manitoba, Saskatchewan, and the federal legislation. But you have to be aware of these differences. There's also regional variations in what tends to be the award made for emotional suffering in human rights cases. Maritime provinces, generally very low. Ontario, more liberal, considerably higher. Same as Alberta and in British Columbia. There are noticeably higher damage awards for compensatory damages in these jurisdictions. So let's sit down and we'll go through all this in detail subsequently, but let's understand the basic differences first.